Most Americans believe strongly in the separation of governmental powers. This was one reason they criticized the Articles of Confederation. The Articles established a legislative body, the Confederation Congress, but they failed to establish separate executive and judiciary branches. Even critics of the Constitution usually applauded its distribution of powers among three branches. Some critics, however, accused the Constitution itself of violating the separation of powers doctrine. For example, this was a major concern of Richard Henry Lee, the distinguished Virginian who made the original resolution for American independence in the Second Continental Congress.
It has hitherto been supposed a fundamental maxim that in governments rightly balanced, the different branches of the legislature should be unconnected, and that the legislative and executive powers should be separate. In the new Constitution, the President and Senate have all the executive and 2/3 of the legislative power. In some weighty instances, as making all kinds of treaties which are to be the laws of the land, they have the whole legislative and executive powers. They jointly appoint all officers, civil and military, and they, the Senate, try all impeachments either of their own members or of the officers appointed by themselves.
In the Federalist Papers, James Madison conceded the importance of this objection.
The accumulation of all powers, legislative, executive, and the judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. Were the Federal Constitution, therefore, really chargeable with this accumulation of power, or with a mixture of powers, having a dangerous tendency to such an accumulation, no further arguments would be necessary to inspire a universal reprobation of the system.
As we have seen, the primary source used by 18th century Americans for the separation of powers doctrine was the French philosopher Montesquieu. Madison claimed this philosopher had been misinterpreted by critics of the Constitution. According to Montesquieu, legislative, executive, and judicial powers should not be united in the same person or body of persons. This, Madison argued, does not mean governmental departments should be wholly unconnected.
Montesquieu did not mean that these departments ought to have no partial agency in or no control over the acts of each other. His meaning can amount to no more than this, that where the whole power of one department is exercised by the same hands which possess the whole power of another department, the fundamental principles of a free constitution are subverted.
A separation of powers is the foundation for a system of checks and balances, but this system is possible only if governmental departments overlap in some areas. Otherwise, they could not restrain each other.
Unless these departments be so far connected and blended as to give to each a constitutional control over the others, the degree of separation, which the maxim requires as essential to a free government, can never in practice be duly maintained.
According to Madison, all defenders of liberty agree on the need for a separation of powers. The real difficulty lies in establishing an effective system of checks and balances.
It will not be denied that power is of an encroaching nature, and that it ought to be effectually restrained from passing the limits assigned to it. After discriminating, therefore, in theory, the several classes of power, as they may in their nature be legislative, executive, or judiciary, the next and most difficult task is to provide some practical security for each against the invasion of the others. What this security ought to be is the great problem to be solved.
How does the Constitution solve this great problem, as Madison called it? What are its major provisions for a system of checks and balances? We shall now turn to these questions. Several parts of the Constitution deal with the legislative power to remove officials of the federal government. These officials may belong to any of the three branches of government, but as we shall see, framers of the Constitution had the President foremost in mind when approving this power. Thus, the power of removal is commonly seen as a check by the legislative branch against the executive branch. Removal from office involves two stages, impeachment and trial. To impeach means to accuse, to bring charges. The Constitution provides for the impeachment and trial of federal officials.
Article 2, Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors.
The power of impeachment has roots deep in English history, reaching back to the 14th century. The phrase treason, bribery, and other high crimes and misdemeanors also has roots deep in English history. These words were familiar to any student of English law in the 18th century. The Constitution also follows the English model in placing the power of impeachment in the lower house. In England, this is the House of Commons. In America, the House of Representatives.
Article 1, Section 2. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment.
After charges are brought, the Senate acts as the trial court.
Article 1, Section 3. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present.
In the Federalist Papers, Alexander Hamilton pointed to the English precedent of impeachments and trials of impeachment. And though the power of impeachment and trial extends to all federal officials, Hamilton identified the primary target of this power, the executive branch. Thus, in America, this legislative power was intended primarily as a legislative check on the abuse of power by the President.
The model from which the idea of this institution has been borrowed pointed that course to the Convention. In Great Britain, it is the province of the House of Commons to prefer the impeachment, and of the House of Lords to decide upon it. As well, the latter as the former seem to have regarded the practice of impeachments as a bridle in the hands of legislative body upon the executive servants of the government. Is not this the true light in which it ought to be regarded?
After a president is impeached by the House, he is tried by the Senate. This power of the Senate occasioned some debate during the Constitutional Convention. James Madison and others believed trials of impeachment should be conducted not by the Senate, but by the Supreme Court, or at least by some tribunal of which the Supreme Court forms a part. South Carolina's Charles Pinckney gave the reasoning behind this position.
I disapprove of making the Senate the court of impeachments, as rendering the President too dependent on the legislature. If he opposes a favored law, the two houses will combine against him, and under the influence of heat and faction, throw him out of office.
Connecticut's Roger Sherman disagreed. Trial by the Supreme Court, he believed, would entail a conflict of interests.
I regard the Supreme Court as improper to try the President because the judges would be appointed by him.
Other delegates favored the Senate because it contains more members than the Supreme Court. The more persons involved in the trial of a president, they believed, the less chance of corruption affecting the outcome. Alexander Hamilton echoed this reason in the Federalist Papers.
The awful discretion which a court of impeachments must necessarily have to doom to honor or to infamy the most confidential and the most distinguished characters of the community forbids the commitment of the trust to a small number of persons.
In conducting trials of impeachment, the Senate, a part of the legislative branch, acts as a judicial body. Doesn't this violate the separation of powers? No, according to Hamilton. Like Madison, Hamilton argued that a separation of powers does not mean governmental departments should never overlap. Indeed, without this occasional intermixture, the system of checks and balances could not operate.
This partial intermixture is even, in some cases, not only proper but necessary to the mutual defense of the several members of the government against each other.
The crimes leading to impeachment, Hamilton explained, are distinctly political crimes, that is, crimes against society as a whole. If a president is impeached and convicted, his punishment is removal from office, along with the disgrace this causes. Conviction does not carry civil or criminal penalties. These must be tried separately, and this is where a president falls within the power of the judiciary.
Article 1, Section 3. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law.
The Constitution contains one other reference to impeachment, and the reasoning behind it is obvious. The first clause of Article 2, Section 2 reads in part,
The President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment.
The Constitution vests power in the President to veto legislative acts. Now, this is another important feature of checks and balances. The presidential veto, like many issues relating to executive power, was a touchy subject for convention delegates. After all, only 4 years had passed since the Treaty of Paris had officially ended the American Revolution. For what had Americans spent their blood and money? For many Americans, the war was fought not just against a particular monarch, George III, but against the principles of monarchy itself. Let it be known, declared Thomas Paine in his famous pamphlet Common Sense, that in America law is king, and there is to be no other. For many delegates, the hated principles of monarchy included far more than the hereditary transfer of power. Essential to monarchy, in their eyes, was a single executive vested with strong powers which he could exercise virtually at his discretion. Thus, some delegates, such as Virginia's George Mason and Governor Edmund Randolph, even opposed a single executive, calling it the fetus of monarchy. These delegates called instead for a plural executive, an executive council instead of a single president. On the other extreme were delegates who vigorously defended a single executive with strong powers. Alexander Hamilton, for example, desired a president elected for life with the power to appoint the governors of every state. This is one reason why Thomas Jefferson, many years after the convention, accused Hamilton of favoring the principles of monarchy. The issue of a presidential veto, or as delegates called it, an executive negative, was especially sensitive during convention debates. The reason for this is illustrated in the Declaration of Independence. Among the many charges leveled against George III, his absolute veto power over laws passed by American legislatures was mentioned first.
He has refused his assent to laws, the most wholesome and necessary for the public good.
American distrust of executive power ran deep. Among the 3 branches of government, the executive usually was feared as the greatest threat to liberty. The legislative branch, on the other hand, was often seen as the repository of liberty. Thus, any constitutional provision granting an executive veto over legislative acts was sure to raise American eyebrows. The original convention plan for an executive veto tried to soften the blow by including a portion of the national judiciary in the veto process. This went nowhere. Then 2 champions of executive power, James Wilson and Alexander Hamilton, moved to give the president absolute veto power, that is, a veto that cannot be overridden by the legislature. Before this proposal went down to unanimous defeat, its 2 advocates were reminded by Virginia's George Mason that Americans would never tolerate a monarch, not even an elected one. The Constitution incorporated this American hostility to the trappings of monarchy. A clause from Article 1, Section 9 reads,
No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state.
The final presidential veto was something of a compromise, but on the whole it was a significant victory for champions of executive power. The president can veto laws passed by the legislature, but this is a qualified veto. It can be overridden by a 2/3 majority in each branch of the legislature.
Article 1, Section 7. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it. But if not, he shall return it with his objections to that House in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If, after such reconsideration, 2/3 of that House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of that House, it shall become a law. But, in all such cases, the votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill.
Revolutionary Americans had a deep suspicion of executive powers. For example, the Articles of Confederation, ratified in 1781, did not even establish an executive branch at all. Why, then, was a strong veto power included in the Constitution 6 years later? A lot happened in America between 1781 and 1787, both in the realm of politics and in the realm of political theory. Many Americans believed that post-war America was in the midst of crisis, and that the government established by the Articles of Confederation was far too weak to remedy the situation. Most delegates to the Constitutional Convention agreed with this grim assessment. They feared the American Republic was on the verge of collapse, and they generally agreed on the reason for this near failure. America, delegates repeatedly declared, suffered from an excess of democracy. Here are some typical examples. Roger Sherman from Connecticut.
The people immediately should have as little to do as may be about the government. They lack information and are constantly liable to be misled.
Elbridge Gerry from Massachusetts.
The evils we experience flow from an excess of democracy. The people do not lack virtue, but are dupes of pretended patriots.
Governor Edmund Randolph from Virginia.
The general object of this convention is to provide a cure for the evils under which the United States labors. And in tracing these evils to their origin, every man has found it in the turbulence and follies of democracy.
In the Federalist Papers, James Madison reinforced this point with his characteristic lucidity.
Liberty may be endangered by the abuses of liberty, as well as by the abuses of power. And there are numerous instances of the former as well as of the latter. The abuse of liberty, rather than the abuse of power, is apparently most to be apprehended by the United States.
A number of important features of the Constitution, including the presidential veto, were designed to check the abuses of liberty, or the imprudence of democracy, as Alexander Hamilton called it. This was one reason the Constitution was attacked by critics as a betrayal of the American Revolution. In the strong language of Richard Henry Lee,
It will be considered, I believe, as a most extraordinary epoch in the history of mankind, that in a few years there should be so essential a change in the minds of men. 'Tis really astonishing that the same people who have just emerged from a long and cruel war in defense of liberty should now agree to fix an elective despotism upon themselves and their posterity.
some modern historians agree with Lee's analysis. The American Revolution, these historians argue, led to the creation of state governments which in many cases were more democratic than the Constitution. Nationalists and other convention delegates were disturbed by these democratic state assemblies because the wrong kind of men were getting elected, men who often hailed from the lower rungs of American society. Thus, according to this interpretation, convention delegates sought to curb the power of state governments, claiming they led to democratic excesses. Some defenders of the Constitution admitted it departed from the principles of the American Revolution. Naturally, however, these defenders portrayed the change in a favorable light. During revolutionary times, they argued, Americans had adopted some mistaken views about democracy and a republican form of government, and these views had caused economic and political chaos. The Constitution, its supporters claimed, corrected these errors. Alexander Hamilton discussed this in the Federalist Papers. Like James Madison and other Americans, Hamilton believed the American Republic was on a downward spiral to anarchy. Why? Because, he argued, prior to the Constitution, Americans had relied too much on the principles of ancient republics. These republics invariably failed because they did not institute safeguards against the turbulence of unlimited majority rule. But political science had made great strides in modern times. Hamilton believed the Constitution incorporated these new and better principles. It was based on an up-to-date science of politics.
The science of politics, like most other sciences, has received great improvement. The efficacy of various principles is now well understood, which were either not known at all or imperfectly known to the ancients. The regular distribution of power into distinct departments, the introduction of legislative balances and checks, the institution of courts composed of judges holding their offices during good behavior, the representation of the people in the legislature by deputies of their own election. These are wholly new discoveries, or have made their principal progress in modern times. They are means, and powerful means, by which the excellencies of republican government may be retained, and its imperfections lessened or avoided.
James Madison agreed with Hamilton. Madison believed Americans had traditionally placed too much trust in the legislative branch. The executive veto was necessary, according to Madison, because legislative tyranny can destroy republics. Referring to earlier defenders of republics, Madison commented,
They seem never to have recollected the danger from legislative usurpations which, by assembling all powers in the same hands, must lead to the same tyranny as is threatened by executive usurpations.
Framers of the Constitution were troubled by the excesses of democracy in America, that is, the absence of sufficient checks on the power of majorities. This concern was part of their reason for instituting a bicameral, or two-house legislature. The House of Representatives was seen as the Democratic branch. Representatives, according to the Constitution, are elected by the people every 2 years.
Article 1, Section 2. The House of Representatives shall be composed of members chosen every 2nd year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature.
Many delegates viewed the Senate as a check on the excesses of the popularly elected House. Senators served for 6 years, not 2, and until the 17th Amendment was ratified in 1915, senators were elected by the legislatures of individual states, not by the people.
Article 1, Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote.
The Senate, as we said, was intended to check the House of Representatives. James Kent, in his Commentaries on American Law, explained the reasoning behind this. Kent was appointed Chief Justice of New York Supreme Court in 1804, and he later became a professor of law at Columbia University. His Commentaries are regarded as one of the most important works on legal theory ever published in America. Kent's remarks on the Senate concur with those of Madison, Hamilton, and many other convention delegates.
The small number and long duration of the Senate were intended to render them a safeguard against the influence of those paroxysms of heat and passion which are apt to prevail occasionally in the most enlightened communities, and to enter into the deliberation of popular assemblies. In this point of view, a firm and independent Senate is justly regarded as an anchor of safety amidst the storms of political faction. The legal presumption is that the Senate will entertain more enlarged views of public policy, will feel a higher and juster sense of national character, and a greater regard for stability in the administration of the government.
Why will the Senate exhibit more stability and wisdom than the House of Representatives?
These qualities, it is true, may in most cases be equally found in the other branch of the legislature, but the constitutional structure of the House is not equally calculated to produce them. For as the House of Representatives comes more immediately from the people, and the members hold their seats for a much shorter time, they are presumed to partake with a quicker sensibility of the prevailing temper and irritable disposition of the times, and to be in much more danger of adopting measures with precipitation, and of changing them with levity.
The House of Representatives, elected directly by the people, was likely to shift with the changing winds of majority rule. The Senate, Kent explained, was designed to check this instability.
A disposition to multiply and to change laws upon the spur of the occasion, and to be making constant and restless experiments with the statute code, seems to be the natural disease of popular assemblies. In order, therefore, to counteract such a dangerous propensity, it is requisite that another body of men should be placed as a check upon the intemperance of the more popular department.
The Senate, in addition to checking the House of Representatives, also was designed to check the power of the President. The President is empowered to conduct foreign policy by negotiating treaties, but such treaties must pass the Senate by a 2/3 vote.
Article 2, Section 2. The President shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur.
Except for the President and Vice President, all members of the executive branch are appointed. The President makes these appointments, and in addition, he appoints justices to the Supreme Court. Again, however, the Senate can check this presidential power. The Senate must approve all appointments of superior officers in the executive branch and all appointments to the Supreme Court.
Article 2, Section 2. The President shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, or in the heads of departments.
We have looked at the role of the executive and legislature in the American system of checks and balances. Now let's examine the role of the Federal Judiciary, and especially the Supreme Court. Framers of the Constitution, in upholding the separation of powers, considered it essential for federal judges to hold their offices during good behavior. This, in effect, means life tenure. Federal judges can be removed only if convicted of the high crimes and misdemeanors specified in Article 2, Section 4 of the Constitution. The Constitution also provides for judicial independence by prohibiting a reduction of salary during the tenure of a federal judge.
Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation, which shall not be diminished during their continuance in office.
In the Federalist Papers, Alexander Hamilton explained the importance of life tenure for federal judges.
The standard of good behavior for the continuance in office of the judicial magistracy is certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is a no less excellent barrier to the encroachments and oppressions of the representative body. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws.
According to Hamilton, the judiciary is the weakest of the three branches of government. It does not wield the sword, nor does it control the purse. Therefore, to prevent it from being manipulated and intimidated by other branches of government, the judiciary requires total independence. This is especially true if the judiciary is to check the excesses of the legislative branch.
The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority. Such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all the reservations of particular rights or privileges would amount to nothing.
Doesn't this render the judiciary superior to the legislature? No, Hamilton argued. It merely keeps the legislature within the boundaries of the Constitution.
No legislative act contrary to the Constitution can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid.
Alexander Hamilton, in his discussion of the federal judiciary, defended a theory known today as the doctrine of judicial review. This is the power of federal courts, and ultimately the Supreme Court, to declare laws unconstitutional. It is important to understand that judicial review is never mentioned in the Constitution, at least not explicitly. The Constitution does not vest the Supreme Court with power to assess the constitutionality of laws. Here are the powers expressly granted to the federal judiciary.
Article 3, Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases affecting ambassadors, other public ministers and consuls. To all cases of admiralty and maritime jurisdiction. To controversies to which the United States shall be a party. To controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects.
If the Constitution does not provide for judicial review, how did the Supreme Court acquire this power? We shall now consider this question.
This is the end of the first of 2 tapes on the text of the Constitution. This material may not be copied in whole or in part without the written permission of the copyright owner. Copyright 1987 by Carmichael & Carmichael Incorporated. The presentation is continued on the next cassette.